वो समाज सभ्य समाज तभी कहलाता है जब सबके अधिकारों का सम्मान हो और सबको समय पर न्याय मिले. What would you do if you don't have the means or the knowledge to navigate the maze that is our judicial system? How will you get timely justice? How will you gather the resources to fight a long drawn judicial battle? Justice is not just a philosophical word. It's a right that every citizen, by the virtue of being a citizen, is entitled to. And a glimmer of hope in this very, very enthralling ecosystem comes in the form of legal aid. No matter what your financial status, if you are in need of legal aid, Article 39A of the Constitution is where the journey for legal aid begins. In India, the right to move the court, the right to free legal assistance, and the right to legal aid are deeply interconnected to the larger idea, the more powerful idea of access to justice. Accessing one without the other would be doing injustice to all the three. Legal aid removes one of the most important and one of the primary barriers to justice, financial aspectability. And that is where, without legal aid, access to justice would remain a distant dream for a lot of us. And to be very honest, legal aid in India is like Wi-Fi in a government building. You don't get it just when you need it the most. Ladies and gentlemen, this is What a Week, our weekly current affairs presentation giving you a 360 degree on a contemporary issue, giving you closure because no one else will. For those of you preparing for the civil services, the topic of legal aid is a UPSC favorite. The UPSC has asked multiple questions from this across the past few years. Legal aid directly correlates to GS Paper 2 and can also be used in a cross-referenced manner across GS1 as well with respect to vulnerable sections. The UPSC, both in the prelims and the mains, has asked analytical, factual, and critically evaluative questions on the idea of legal aid. Now, through the course of this, we shall be addressing the following aspects of legal aid. 1. What is included in legal aid? 2. Who is entitled to legal aid services? 3. Why do you even need legal aid in India? 4. How does legal aid come about to be? The evolution of it. 5. How is legal aid executed as a policy idea? 6. What are the multifaceted barriers to legal aid? 7. How can governments, non-governmental organizations, civic societies collaborate with each other to improve the state of legal aid in India? Next, we also look at the culture of pro bono legal practice. And finally, we answer the question, the way forward. What is included in legal aid? One of the primary legislations governing legal aid, the Legal Services Authorities Act of 1987, under Section 2, Clause C, gives a very wide aspect to the idea of legal aid. Not only does it cover the cost of an advocate, it also covers all charges incurred while drafting a petition. It also includes submission charges. It includes the charges to procure and transmit a witness. It also finally includes getting documents from court during the process of the judicial proceeding. So the fact of the matter remains, legal aid is not just about getting you a lawyer. It's about taking care of every aspect which is included in the process of a legal proceeding. Who is entitled to legal aid? Though the list is fairly exhaustive, the people who are entitled to legal aid primarily come from some degree of vulnerability. To name a few, first, individuals who are economically disadvantaged, largely meaning those people who are below the poverty line. Two, people who are socio-economically or socio-educationally backward. This primarily refers to people who come from backward castes. They could be scheduled castes, scheduled tribes, or even other backward classes. Three, women, and particularly those women who suffer from instances of domestic violence, matrimonial violence, property disputes, or any degree of family intervention. Fifth, children. Children are particularly sensitive when it comes to legal aid, and especially those children who have been caught up in juvenile cases, who are entangled in child protection matters. Sixth, people who suffer from disabilities, whether those disabilities are physical or more recently, even mental disabilities are recognized under legal aid. Seventh, victims of atrocities, mass violence, disasters, trafficking, who are entitled to certain legal rights but are devoid of the same. And apart from this, other vulnerable groups. They could mean people in custody, beggars, the elderly, homeless, and so on and so forth. So it is safe to say that the ambit of the people being covered under legal aid is fairly wide. Despite that, very few actually receive qualitative legal aid. Why legal aid? The answer to the question why legal aid has constitutional and very, very realistic justifications. Constitutionally speaking, it is through legal aid, it is because of legal aid that larger principles of equality before law, rule of law, constitutionalism, the rights theory are upheld. And practically speaking, the complexity of our judicial processes, the vagueness of our procedures, the state of vulnerable sections in society, the unjust incarceration of those sections, and the larger idea to promote social justice are all reasons that come together and make it necessary, especially for a country like India, which has always taken pride in being a welfare state, to do whatever is necessary to give representation to those who need it the most. Hence, legal aid. How did legal aid come about to be? Well, during the British rule, not much focus was given to legal aid, though our Mahatma Gandhi did everything in his might to champion the cause of legal aid. He often spoke about it during his speeches, and he also made it one of the primary pieces of agenda while campaigning for the freedom of this country. After we became independent, we were blessed to have a rather progressive constitution. And the constitution gave us the necessary impetus that was needed to sort of bring legal aid into better light. Now, two judges can't be forgotten when legal aid is spoken of: Justice Krishna Iyer and Justice P.N. Bhagwati. Both of these judges have made contributions to legal aid that has made legal aid a reality in the country today. In 1977, Justice Iyer and Justice Bhagwati had actually titled a report. The report was called National Judicare: Equal Justice and Social Justice. It is this report which had recommended the establishment of the National Legal Services Authority. And eventually, the Parliament, of course taking its own sweet time, enacted the National Legal Services Authorities Act of 1987, a decade after the report was submitted. And as we all know, it is the judiciary who often champions these kind of rights. It was in the Hoscott versus the state of Maharashtra judgment of 1978 where the Supreme Court for the first time recognized the need for legal aid, the need for right representation. This judgment was India's first ever judgment recognizing legal aid in any form, capacity, or manner. Thereafter, a series of judgments followed, and there was, in fact, a holy trinity linking legal aid, public interest litigation, and judicial activism. Let's understand what this trinity is. If legal aid is about fighting for the rights of the people who can't fight on their own, public interest litigation makes it easy for someone to come to court on behalf of someone who can't come to court. And the judiciary takes an opportunity moment out of this and then creatively interprets the law so that larger justice is delivered, which is why there is an inherent relationship between legal aid, between public interest litigations, and judicial activism. In fact, you will see this as a tool often used by the Supreme Court in seminal cases, such as India's first ever case on women harassment at the workplace, Vishakha versus State of Rajasthan in 1997, in Khatri versus State of Bihar in 1981, in Manoj versus State of Haryana in 2000, the Supreme Court repeatedly reaffirmed that the right to legal aid is indeed an implied fundamental right. It's one of those rare occasions in Indian legal and constitutional history that a directive principle of state policy has been given the status of an implied fundamental right. And then came the landmark judgment of Ramakant versus State of Madhya Pradesh in 2012. It is in this judgment where the Supreme Court categorically held that legal aid must be given to somebody irrespective of the severity of the crime committed if the person cannot afford justice and representation. And that is why today legal aid is a lifeline that pulls you from the sea of injustice towards the beacon of justice. So, how is legal aid implemented in the country? As usual, the story starts with the Constitution of India. And the Constitution contains a bunch of fairly important articles which directly or indirectly give a reference to legal aid. As we discussed before, the story starts with Article 14, which refers to equality before law and equal protection of law. The absence of legal aid puts certain communities at a disadvantage and therefore also calls upon the state to undertake affirmative action to make sure they get to justice. Secondly, Article 21, India's most glorious fundamental right, which guarantees to every person the right to life and personal liberty, has a direct intervention with legal aid. Apart from this, Article 22, Clause 1, which is a part of the larger set of fundamental rights, which are to deal with arrests and protections to deal with arrests. They also refer to certain legal aid-centric provisions. When our directive principles are spoken about in Part 4, Article 39A categorically refers to the provision of free and equal legal aid. While these are your constitutional provisions, your new criminal laws also give you enough exposure to legal aid. So from the law front, we look at the institutional front. The Parliament enacted a law called the NALSA in 1987 and created the National Legal Services Authorities Act. The Supreme Court also at the apex level has a Supreme Court Special Committee for Legal Services. At the state level, you have the SALSA, which is the State Legal Services Authorities Act. At the district level, you have a similar authority. And then below the district level, you have the Taluka Legal Services Committee, which often organizes India's greatest experiment with grassroots judiciary, Lok Adalats. Because think of it, the truest form of justice, the truest form of welfare is when it is delivered at the grassroots level. And that is exactly why your Lok Adalats are a forgotten but a very important aspect of what is called legal aid. Moving on to the barriers to legal aid. Let me set some context. According to the India Justice Report of 2019, only 15 million people were awarded some form of legal aid since 1995, while the reality is 80% of the population is technically eligible for legal aid. So what's stopping us from accessing something which is built for us? First, geographical challenges. India's vast size, diverse geography, uneven infrastructural development makes it very difficult for citizens to access their legal rights. Legal aid services, officers, authorities, you'd find them mostly concentrated in even geographies, in urban centers. If not urban, surely semi-urban, which means legal aid is unable to reach where it actually should, the last mile, the grassroots, the utmost rural part of India. The second barrier to legal aid is literacy. If we rely on the 2011 census, 74% of the Indian population is technically literate, which means we can read and write a recognized language in our own ways. Now the problem is this: being technically literate and being functionally literate are two very different things. Being functionally literate also comes with being functionally legally aware. On top of this, most of the legal proceedings, police proceedings, departmental proceedings, court work, judgments, documents are all in English. So imagine a tribal woman cannot even understand the FIR that she might be juggling with. In fact, in rural India, a critical issue is the sheer lack of awareness of legal justice. So from literacy, we then move to social and cultural barriers. India, unfortunately, invented the caste system. And this caste system is so deeply entrenched in society that the barriers created by the caste system, the boycotts invented by the caste system, go deeper than the ordinary eye. This is why the national campaign on Dalit human rights has frequently highlighted how people who come from certain sections are always at a disadvantage. In fact, if you look at reports which have been produced by something called Project 39A, an extraordinary organization that works out of the National Law University in Dwarka, Delhi, their reports categorically state that people from disadvantaged sections get sentenced to capital punishment more, and they often can't afford a defense. And it's not just about caste, it's about each and every instrument of social stratification. Patriarchy, for example. A lot of times, women have lesser access to justice than men. When we look at issues of matrimonial violence, family law, divorces, custody of children, women are often left hanging to fend for themselves. One, they don't know where to go, and two, they don't know how to afford once they know where to go. And this becomes a socio-cultural barrier. And if this wasn't enough, the final barrier is, are we really spending enough on legal aid? A lot of the money for legal aid in the country comes from our budgetary processes. The Ministry of Law and Justice is the agency responsible for giving grants to these organizations. If you just take the numbers, for 80% of the Indian population who's eligible for legal aid, the National Legal Services Authority was given just 150 crores in 2018. And you might think the number would go up as the years come close. This 150 crores actually becomes 140 crores in 2020 and 2021. Today, almost reaching to a ballpark figure of 100 crores. If you actually calculate the per capita spending on legal aid in India, it's about 75 paisa. Let that sink in. 75 paisa per person is what we spend on access to justice. So how can government, NGOs and civic society try and make legal aid better? Let's understand this through multiple perspectives. First, the very lawyers who are supposed to fight legal aid cases. Now, their plight is another story altogether, and it actually is a very difficult problem. The legal aid councils in India are not paid enough. But that's no excuse, because what they do more often than not is more than embarrassing. Very often, they ask their legal aid clients to cough up more money in the name of the proverbial Indian adjective, kharcha pani. And this makes legal aid unaffordable, the primary problem that legal aid wanted to solve. Second, more often than not, it is not considered a matter of pride when a lawyer practices in legal aid. More often than not, within the legal fraternity, they are stigmatized. They're often considered as people who don't have great caliber. And more often than not, it's the junior lawyers or relatively incompetent lawyers who end up taking these cases. For more references, there are enough and more Netflix shows that tell you more about this. While this is one aspect to this, a good innovative solution has been to set up legal aid clinics. But the problem with legal aid clinics is most of them are understaffed. Most of them are underfinanced. And adding to the already burdened judiciary, these clinics are not being able to make an impact. And generally, how legal aid is understood is that if the lawyers have a reputation of not being competent enough, people only resort to legal aid when they have nowhere else to go, which also further complicates the process. No doubt, several law schools in the country have pro bono legal clinics. Several governments have legal aid services schemes running. But are they truly efficient? Is real work actually being done? And there are some very instances of good work. Let's understand this better. When the problem is so severe and the issue is so grassroots, government alone can't handle it, NGOs alone can't solve it. The best solution is a partnership between the state and civic society. Take the case of a collaboration between NALSA and a Delhi-based NGO, the Human Rights Law Network. And they have been instrumental in providing legal aid to people who have been affected by socio and environmental legal injustices. Today, several NGOs like the Multiple Actions Research Group or the Socio-Legal Information Center enable access to justice so that a gap is actually built. The problem is multidimensional. The solution can never be singular, and that's the issue with legal aid. Can the pro bono culture help? So, pro bono services are basically services which are rendered without a fee. Now, globally, especially in the West, pro bono legal services are actually celebrated. What if we could strengthen the pro bono ecosystem in India that actually helps legal aid? There are many ways to go about this. Firstly, if we start recognizing great pro bono work, it gives greater visibility to lawyers to engage in pro bono work. And greater visibility to lawyers therefore enhances their reputation. The US has been doing it for decades and decades together. The US, in fact, has something called the Pro Bono Publico Awards, which celebrates lawyers who have engaged in great pro bono services. Secondly, you could sort of make this compulsory. The bar associations, the ministries, law schools, the government, everyone could come to a consensus and somehow create a bare minimum requirement of a certain number of cases that every lawyer should take up pro bono. Thirdly, you could also encourage cross partnerships between law firms, NGOs, and these legal authorities to transform pro bono models. Now, call me crazy, but the world works on incentive. What if you could incentivize law firms and tell them, if you do X number of pro bono cases, we can give you a Y percentage tax incentive. So, therefore, they will use their resources, the people will get the best representation, hopefully, and legal aid will be more than just a thought in India. In fact, technology has played a very important role. There have been platforms like the Lorato, which has really helped in legal awareness. And at the end of the day, you're as good as you are aware. Legal awareness campaigns, celebrity endorsements, these kind of things can go a very long way in making people realize the value of legal aid. If celebrity endorsements can make polio a thing of the past, we must make legal aid a thing of the future. The way forward. Legal aid is a complex problem, and complex problems require very elegant solutions. From more legal aid clinics to legal awareness, tele-law, technological data consultations, using AI, there are enough and more solutions. If lawyers are too busy, why don't we institutionalize the system of paralegals who can assist the lawyers delivering legal aid better? Surely, the government has launched several initiatives. One of them is the Diksha initiative, which seeks to make legal aid a far clearer reality. But a lot needs to be done. See, legal aid is not just about going to a court. Legal aid is at the end of the day about a person's dignity. The judiciary should be the knight in shining armor. People should have the faith to come to a court so that they are not in the clutches of cross personal conflicts. And only when you respect the process of the courts do you truly achieve the ideals of democracy.